Hello, everyone. It's Brett Glenn from Compass Legal Planning, and I thought I'd bring you another episode of Ask Me Anything. This is where I have clients and friends and people on Facebook or other media email me questions or direct mail me questions, and I try to answer those questions here to add some value. The first question I had from a client is, what estate planning documents should my son, who just turned 18 and is planning to go to college next spring, have in place? And, as you know, when a person becomes an adult, they can start making their own decisions. They can sign contracts. They can do a lot of things. And whether that's a good thing or a bad thing, it depends on your particular situation. But one of the other things that's important is that as the parent, when your child turns 18, you can no longer make those decisions for them because they're adults now. And they have to make their own decisions, or at least with your help. With him going off to college, assuming that he's going to be not necessarily living in your home anymore, maybe out of state, out of town, or whatnot, it's important to have some documents in place because he is now an adult. There may, something could happen to him where he may not be able to act on his own behalf as an adult, and without the proper documents in place, you're helpless to help him. So what I like to tell my clients to do is get at least a durable financial power of attorney that would allow you to make business decisions and financial decisions for him and on his behalf in case he was incapacitated when I was unable to do it himself. That's pretty important. Now, these durable powers of attorney have certain powers, and you can be specific about certain powers you want to give and some that you don't want to give. In his case, the ones he wants to give you. But for the most part, a durable is pretty all-encompassing in case he's incapacitated. Another document that's really important to have is a healthcare power of attorney, because as you know, as an adult and a parent of a minor child, you're able to make those medical decisions for them. But as an adult, you're an interested party, and the doctors and healthcare providers will listen to you, but they're not obligated to do what you're telling them to do because he's an adult. If he's incapacitated and can't make decisions for himself, the healthcare power of attorney will give you the power to make those medical decisions. Those go hand in hand with advanced healthcare directives as well, where he states what his wishes are under certain circumstances if he's incapacitated and can't make decisions for himself. So those are definitely documents you want in place if he's going to be away from you. Lastly, a HIPAA release that allows the doctors and medical providers to talk to you as a parent would be fantastic to have in his record so that they would be able to talk to you. And if that doctor's out of town, it needs to be in his record so they can reference those records and see that they have authority to speak to you with that HIPAA release. The second question is, how can I protect my home and only be able to leave it to my son in my will and not his wife in case they divorce? What documents do I need to prepare? My spouse has already passed away and I only have my son with me. I'm leaving my home to my son. However, he and his wife are in an unstable relationship and I don't want his wife to get any of it if they divorce. That's another very good question. First of all, in your will, you're stating your intentions, and the court may or may not follow your intentions depending on whether your will is found to be valid. But understand that a will requires a probate, and probate is a court action, and a court action can involve conflict, including your son or your son's wife making claims within that probate case. So it is important that you left it to him in the will, and if the court follows your wishes, it'll be given to him as separate property. Important to note, though, is that if something happens to your son and she's an heir of his, which she is because it's his spouse, then she could end up inheriting that home from him. So there are other ways to handle this, and one of those ways is a trust. A trust stays outside of court because it's not a court process. It's not a probate process. It's a contract that you make with yourself for the benefit of yourself while you're alive, and then for the benefit of your family or your son in this particular case after you pass. So in a trust, you can place the house in the trust with specific conditions on it that it'd go to him, which it would never belong to him, but it would be his to use in the trust, which is important because he'll never own the trust. He'll never own the house, but he'll be the beneficiary of that trust and be able to live in that home. And then when he passes, whatever you state in your trust is to have happen to that home is what's going to happen, whether that be it go directly to his children, whether it be sold and his heirs get the money for the home, or whatever you decide, because like I said, it's a contract that you create. The sky's the limit on what you want to do, but a trust will definitely keep it from directly going to his wife in the event of a divorce or in the event of his death or incapacity. that's a good question. The last question is, what type of documents would I need to appoint a guardian if I were to pass away? I'm a single mother and my daughter's father is abusive. Would I need an attorney for these documents? What type of documents would be upheld in court? And how can I avoid custody going to my daughter's father, who has a long history of domestic violence toward myself and another female? This is a tougher question. One of the things that's important to note at the beginning is that courts do not like to break families up. So if something were to happen to you, you're the custodial parent, is my assumption, but and he's not. So if something were to happen to you, he would become automatically the custodial parent unless his rights have been terminated in some way, shape, or form, which you didn't indicate in your question. So under normal circumstances, a non-custodial parent is going to gain custody of that child when the custodial parent passes. Now, is there a way around this? Yes, but it's a very hard road. It's a long road, and it could be a very expensive road. However, it can be done. And the way it would happen is that you could have an estate plan put in place that has guardianship nominations of who you want to take care of your child or children in case something happens to you. Now, the court will automatically default to the custodial parent, the new custodial parent, which would be him. However, your nominated guardians can file a guardianship case, and it would be a court case, and they would provide him notice to come fight it, apparently. And so there's going to be a court case. Well, in that court case, there can be evidence that you leave behind for those guardians about his unfitness to parent that child, about the domestic violence, about those things you want the court to know. And one of the documents we would have in that estate plan would be called an exclusionary document, where it's a sealed document that only comes out, kind of open in case of emergency, of the father stepping forward in that guardianship case and wanting custody. You could open that up and it could contain evidence that would be specific to your case of why this court should give custody or guardianship to these guardians instead of the actual biological parent. Again, it's a hard road, but it can be done, especially if there's evidence like police reports and just really good evidence showing that he is abusive and would be considered unfit under law. And then there's a good possibility at that point that the guardians could get custody of that child. So anyway, that's Ask Me Anything for this particular week. Look forward to seeing you guys and doing more of these in the future. Have a great week.